All right, once again, thanks to everyone who's joined today's webinar. As I mentioned briefly before, this will be the first in a series of webinars that we will be running on PPSR. Today, I'm joined by Terry Ledlin, who's the CEO of Ledlin Lawyers. So the purpose of today's webinar, we will cover off what exactly is the Personal Properties Securities Register, what is the Act as well, how to register and what you would need to register. We will run you through some case law examples, particularly in situations where companies have failed to register. And then finally, we'll talk about the January deadline for registrations. So just some brief information on CreditorWatch. We're Australia's leading commercial credit bureau with over 50,000 customers. The products we have include credit reports, monitoring alerts and debt collection tools. We've just released our PPSR capability and our Apply Easy online credit application. We find that our service is very affordable for all businesses, from sole traders through to public companies. In terms of Ledlin Lawyers, they're a boutique CBD firm based here in Sydney with over 50 years experience specialising in credit management, collections, commercial litigation, insolvency and commercial documentation. As I mentioned, Terry is joining the webinar today to provide some good insight on his experience with PPSR and who he's dealt with in terms of government agencies and private and public companies as well. There's some information on ourselves. I won't jump into that in too much detail. But what I might do is just kick off with a poll. So what I would like to find out is if you're currently registering your security interests on the PPSR, and I'll kick that off now. We might just give it a minute for everyone to respond to that. All right, we'll close off that poll, but it's been good to see that over 55% of the attendees are currently registering on the register itself. 37% don't currently register, and there's actually 8% of you who don't quite know what PPSR is. So hopefully we can provide some good insight to you on the register itself and why, in fact, you might need to register. From here, I might hand over to Terry to provide some insight on whether the PPSA affects you.
Thanks very much, Paul. Well, can I just say that the PPSA, the Personal Properties Securities Act, is one hell of an act. If you are confused, then don't be feeling alone. The line for confusion starts over there. The facts are that when this Act came out, we were all confused because the Act introduced language and concepts that are fairly alien to us. The good news is, and here is the lawyer's disclaimer, the good news is that we're going to try and explain the Act and how it works in plain English. The disclaimer is, or as best we can. Just a couple of things. During this presentation, I'm going to refer to what we call light bulb moments, which we hope will shine a light, if you like, or provide that moment of clarity. Because once you get a fix on the Act and how it works, and my hope today is that when you sign off, you will have a number of those moments of clarity, and the Act will seem a lot less daunting for you. So let's climb into this Act. So the first slide that I want to go to is, of course, what property are we talking about? And the property that we're talking about is basically personal property. Now, you might think you know what personal property is. Personal property is anything that's not real property. So real property is land, buildings, fixtures, that type of thing. Personal property is basically anything else. In the old days, it used to be referred to, or personal property was referred to as chattels, i.e. anything other than land. So as we suggest, it includes goods, namely the goods that you sell. It can include perishable goods. It includes cars, aircraft, watercraft, and indeed, its provisions also extend to animals, i.e. items of personal property. Your dog may be sweating as we speak. Hopefully not. So the question is, how does the PPSA affect you? So, as the name suggests, it's about personal property. So, some questions for you are, do you sell goods on credit or provide credit facilities to anyone? Do you have goods or assets located at other people's premises? Do you supply goods on retention of title terms? Do you supply goods on consignment? As indeed happens often in the motor vehicle industry. I'll sell the car for you, you place it on my lot, and if we get a buyer, we'll do a deal about the proceeds. The Act also applies not just to physical things that you can grab hold of, but it also applies to certain rights. One of those rights might be a license to use any of your products or trademarks or IP. And of course, one of the things that people don't always have regard to is guarantors, because if you've got deeds of guarantee, you might want to not only include a clause that gives you a right to place a caveat over a guarantor's property, but you might also think about taking a security interest over any of the guarantor's personal property. We had a matter, just a quick war story, we had a matter where we were chasing a fellow whose only assets consisted of a vintage car collection. Sadly, we didn't have any registered securities, for want of a better word, over those assets. Otherwise, we could have put the client in a protected position so that the client didn't end up just being an unsecured creditor. So let's just move on to the Act itself. So this Act, and just before I launch into this, I want you to know this Act is not unique to Australia. Our Act is based on the New Zealand Act of 1999. This Act came into effect in January 2002, but in fact it was enacted in 2009. So our cousins, of course, are 10 years ahead of the game. In addition to that, similar acts exist in Canada, France, and a number of American states. So the good news is that they have suffered too because of this Act. So we're not suffering alone. The urban myth is that the Act was introduced by Mr. Philip Ruddock, who was the then Attorney General. And before he left office, he cast his eyes around his file cupboard desk to look for a legacy, something that he could leave behind that would mark his stewardship of being Attorney General, his eyes rested on the New Zealand Personal Properties Securities Act, and the rest is history. As somebody said, if only his eyes had rested somewhere else. So it commenced on the 30th of January 2012. It replaced over 70 pieces of legislation and 40 different registers. And all of that was consolidated into one national system and one national register. And the register, of course, is the PPSR, the Personal Properties Securities Register. The why of the Act, in other words, why do we need this Act? It was said that the Act would, the 4 Cs, this is not a sailing term, the 4 Cs, we increase consistency, we increase certainty, we reduce complexity and reduce cost. That's the why. Frankly, there are some people who would query how many of those whys have actually been achieved. We know a lady who presents this stuff to judicial officers, judges and registrars and magistrates, and she told us that she was giving a seminar on the PPSA to these judicial officers. When she was halfway through, one of the judges sang out, "You have to be a lawyer to understand this stuff." So if it's confusing for our judicial officers, then it's not surprising that the man in the street has issues with it. So let's look a little closely at the Act. So this Act establishes rules for creating valid and enforceable security interests. Now, I said before there are certain light bulb moments that I'm going to refer to as we go through this, and at the end I'm going to summarise them for you. And again, if you can get your mind around these light bulb moments, then hopefully the whole thing will just, in a lightning bolt of clarity, it will all become crystal clear. So one of the terms that you've got to get your head around is what we refer to as security interests. And I'll come back to that in a minute. So the Act establishes these rules for a system that enables enforceable security interests to be registered. And by registration, you get a priority. And of course, this Act comes into its own when there's an insolvency event. So just think about this for a moment to try and get your head around this security interest. If you are buying a house, you go to the real estate agent, you find a property, and when you found it, invariably you'll end up at a bank, a financier, and that bank will lend you money to buy the property. Once you buy the property, the bank advances the money and it takes in return a mortgage. And I think most people would have heard of the term mortgage. In other words, that's the bank security. If you don't pay, then they can exercise their rights under that mortgage and take possession. Under the PPSA, if you are buying goods on credit, then the Act allows the seller who has funded those goods to take a security interest in the goods. And we'll talk about that in detail in a minute, but the seller, if you like, has a security interest in those goods, and the seller then alerts the whole world via the register that they have an interest. So the interests that we talk about and the security interests are these rights that the seller has, different from the rights the bank has in respect to the mortgage, but rights just the same. Now, to give you a sense of how we now have a new language, and I spoke before about language being somewhat alien and the terms being somewhat alien. To give you a sense of that, if we have a quick look at some key terminology. So here's some terms that, again, might seem a bit daunting when you look at them, but once you take the time to just let them percolate a little bit and get your head around them, then it becomes relatively easy to understand them. So a security interest is, as the definition says, an interest in personal property created out of a contract between the parties, which will secure payment of a debt or enforcement of an obligation. Now, most times, if you go down to the retention of title definition, most times the security interest will be that retention of title. And the retention of title basically says, look, I'm going to sell you my goods. You can have them, you can store them, you can keep them, you can sell them. You can do all sorts of things with them, but until you pay me, they're still mine. So title doesn't pass until payment. And it's that right to get that payment that is the interest that the Act seeks to protect. So there's an annexure, I think, a download with the webinar where you can get all these definitions. So I won't go through them in detail, but what I do want to talk about now is the register. So we have a security interest. Now we need to tell the whole world about it. So if you think of the register as an online notice board, it tells the world, or anyone who searches it, if there are any interests that may rank ahead of you. And there's a critical point here to be made, and that is that here's the underlying theory. The Act is very prescriptive. You've got to get the registration correct, or it's likely to mislead people. And if it misleads, then the registration will be ineffective. So, most important, if we have a quick look at what are the benefits of registering, then, or if you like, what's in it for a buyer, here are some of the reasons. If you're buying goods, you want to make sure that there's no encumbrance. Nobody else has an interest in them. I said before that registries around the country are now part of the PPS register. So things like revs, in the old days, you'd go to revs to see if somebody had an interest in a motor car. That's gone. What you now do is you make an inquiry on the PPS register. The important thing is, though, and it's number 2 here, that this Act comes into its own when there's an insolvency regime, because if there's an insolvency regime and you've not registered properly, then you will lose the interest that you had in those goods. Okay, so what's in it for a seller? So there you are. You've got a retention of title clause or a Ramalpa clause. Ramalpa, by the way, for those that are interested, comes from an English case decided in 1976. Basically, what it says is that it's possible to have a transaction where title remains with the seller until the goods are paid for in full. So if you want to retain that interest, and we'll talk further about it in a minute, if you don't register, then you'll no longer be protected. So again, if a seller is not registered an interest, they'll be considered unsecured. And if you are unsecured, trust me, you are at the bottom of the pile. In liquidations and insolvency events, unsecured creditors outside of shareholders of a company basically rank last. There's invariably nothing left. And of course, the big news is that you should register as early as possible because it helps the seller stand the best chance of being first in line over others. So it's a priority system. Now, leasing and hiring, what about those things? Well, there are certain circumstances where if you are leasing, renting or hiring goods, then as the last paragraph on this slide says, a registration will protect the interest in the goods being hired while they're not in possession of the owner. We're not going to go into leasing and hiring today. Our purpose today is more to talk about the Act and the register. So let's just have a closer look at security interests. Paul, did you have any questions relating to this?
Yeah, thanks, Terry. My question was really around looking at security interests. You mentioned that the retention of title clauses. If in my contracts, if I've got a retention of title clause, why do I still need to register that? Don't I have a standing at law with a retention title clause?
Okay, that's an excellent question. I can't tell you how many times we get asked that. And here again is another what we call light bulb moment. Here's how it works. Credit account on its own is not going to create any sort of registrable security interest. So if you're selling on terms, 14-day, 30-day terms, etc., that's not going to do anything for you in terms of creating an interest. The way an interest gets created is, of course, by contract. And an ROT is the interest. The interest in an ROT is the right of ownership that vests in the seller until payment. It's created by contract, and your terms and conditions are your contract with your customer. So what we're going to say to our customer is this: look, as I said before, you can have possession, you can have control, you can have the right to sell, but ownership is mine until I get paid. So you can't rely on title or ownership and contract terms. You need registration. So you need two things. You need a security interest and you need a registration of that security interest. That's the big mover. So when should a PPSA registration take place? And the bottom line is ASAP. As soon as you're going to be dealing with a new customer, or if you're dealing with an existing customer on new terms. In fact, if you haven't registered existing customers, that's okay. You can still go ahead and register them. However, there may be time periods involved before the registration becomes truly effective. Now, the big news is, of course, there are people out there that have registered for 24 years and 11 months because it's the same cost. And the issue is this: what happens when you want to update your terms? And this is a critical question.
And before we jump into that, sorry, Terry, I might just launch another poll. Really, the question is for everyone, how many times have you updated your terms in the last 7 years? So I'll launch that now and give you a minute just to respond to that, and then we can jump into dealing with terms and the like.
Yep.
So we've had a really good response to that poll. 37% of you have updated your terms once. 29% have updated their terms 29% of the time. 16% of you have updated your terms more than 3 times. And in fact, there's actually 19% of you that have never updated your terms in the last 7 years.
Okay, that's interesting. Well, some people have got some decisions to make. Let's just have a quick look about how to register. So the PPSR is highly prescriptive. And as I said before, the rationale is the register is there for notification to the world. If you don't register properly, then you mislead people, namely anyone who's searching. So the penalty for not getting it right is your registration is ineffective. It will not protect you. What do you need to register? We've outlined some of the things that you need to register. There are others, and if we now go to the financing statement. So the financing statement is, in effect, the data that gets registered in an application for registration on the PPS register. So the sort of information you need are the secured parties details. That will be you if you're the seller. The grantor's details, that will be your customer. A description of the collateral, namely the goods that are being sold and the proceeds. The end time for the registration, how long is this registration going to last, and whether that's secure, what that security is, or is it to be a PIMSI? So just a couple of points here. And again, a light bulb moment. The Act does not create security interests. Okay, just let that sink in. It doesn't create security interests. What it does, it sets up a regime where the holder of a security interest can register a financing statement which gives notice of that security interest. So it's not the security interest per se. Okay, so what happens if you don't register? Here's the crunch. If a grantor, namely your customer, becomes insolvent, which means they go into administration, or perhaps a liquidator is appointed, or indeed a trustee in bankruptcy is appointed, and you don't register, whatever rights you have will be ineffective, because creditors who did register will take priority. Not only that, you'll not only lose access to your goods, you'll also lose access to any proceeds of goods. So it's a double whammy. And here's the big crunch and another light bulb moment. And I need you just to think very carefully about this. The law used to be that if I owned something and I sold it to you, nobody in the world had a better right to that item except me, because I was the true owner. Under the PPSA, what happens now is this: my rights of ownership get trumped, and they get trumped by possession. So if we just think about that for a minute, my ownership rights no longer exist. What's happened is somebody else has possession and control over these goods, and I am now on the outer. Now legally, that's a big step. We no longer can rely on our rights of ownership. So we talk about possession being 90%. Under the PPSA, it's 100%. So if you don't register and you lose control by virtue of an insolvency event, you don't have any more rights. They're gone. So that is a critical thing to remember. Let's just have a look at a couple of cases very briefly about what happens if you don't register. And again, these cases illustrate a very vital point, namely about vesting and what I was just talking about. Maiden Civil was one of the first cases that was decided. Effectively, what happened, if you cut through all the guff, Maiden leased some excavators. The owner of the excavators did not register its lease security on the register. There was then a general security agreement that they entered into with Fast Financial. Fast, by name, by nature, went and registered their interest straight away. Maiden went into voluntary administration because the owner didn't register its security interest. The excavators ended up being vested in Maiden. So in other words, the customer ended up with the ownership, not the true owner. So that's the sort of thing that can happen. But if you think that's bad enough, try and feel sorry for GE if that's possible. Next case, commonly referred to as the Forge case. Again, cutting through the guff, it went something like this. GE entered into an agreement with Forge where they would lease gas turbine generators. GE didn't believe it was necessary to register their security interest. Forge went into administration. Forge maintained, namely at the behest of the liquidator, that the turbines, because of their weight, had become a fixture, therefore become part of the land. The court held that the turbines were not fixtures, so the registration should have taken place. Now, that's all pretty stock standard stuff, but in GE's case, that exercise cost them roughly $50 million. That was the value of those turbines. Pretty scary stuff. So the thing to remember is possession and control will lead to loss of title and ownership if you don't register. Now, just before we get on to the January 2009 deadline, just a quick revamp of those light bulb moments. You've got to distinguish between land and personal property. You've got to register on this online notice board. A credit account or an account application does not create a security interest. You need a contract to do that. A PIMSI is a special sort of registration which can give you a super priority, which perhaps we'll talk about next time because I see the clock is ticking down. You will lose your right of ownership if you either don't register or your registration is faulty. And that's a big call, because if you don't register and your customer has an insolvency event, then you're going to miss out. It's that simple. You get to take a hit where it would have been so easy to just register. So we say, as Nike says, just do it. Expect the unexpected and minimize your risk. Now, the thing you also need to be conscious of is that in January 2009, the first 7 years is up. January 2019, the deadline is up. So if you've got registrations that were for 7 years and you took them out as transitional registrations or any other registration, they're going to be coming up. This is an opportunity to make sure that your registration doesn't lapse, because you have to maintain what's called continuous perfection. And continuous perfection means that you're constantly registered and registered properly. So what we're saying essentially is you need to act now for those particular registrations. Next time round, we're going to talk about the different ways of re-registering and the effect of changing your terms on your PPSA registrations. But for the moment, I think that basically brings us to an end. And perhaps, Paul, you might want to talk about the next webinar or anything else that you wanted to talk about.
Yeah,
thanks, folks.
Thank you, Terry. Just a couple of points for the listeners. The session has been recorded today, and we will make that available on the website for you to go back and review. The slides themselves will also be available online. One other point, we have had a lot of questions come through from listeners, and we will get to those individually as well. So apologies we didn't have time today to get to those. As Terry mentioned, our next webinar will be on the 6th of September, and there'll be a formal invitation that will go out as well for that. But once again, thank you for your time today. If you do have any questions, you can get in touch with us directly. As I mentioned, there will be a link to access any further questions you have, or you can get in touch with your account manager or CreditorWatch directly. Thanks very much.